All right, good morning, everyone. So again, my name is Erin Fleury with Alpine Legal Services. So today I'm going to be discussing wills and estate planning, which happens in the beginning, and then the probate and administration of estates that happens at the end. Also cover some updates as well as things that might have come up that's new, questions I've had from clients that are recent that I think might apply to others as well. All right, so the electronic presence of wills is something that came out December of 2021. I don't think it was a coincidence that it happened around the COVID era as well, but there was legislative changes that you can have an electronic will with electronic signatures. Before you couldn't have this, you had to do everything in writing with two witnesses. Now you can do everything online and sign digitally. I think what's happened though is while perhaps the intention might have been to embrace technology, also be mindful of COVID, I think a lot of firms and companies have been using this to advertise fully digital wills as being cheap and convenient to have a will prepared. We would not advertise it as usable in that way. There's purposes for it, but it should not be used solely just to be cheap and convenient. We actually do not recommend preparing an electronic will unless there's very specific situations where it comes up. Some of these reasons is that the file might get lost or corrupted over time. This is more common than some people may think, just because you're dealing with people who have Macs, Microsoft, so things like that can come up, difficult to recover. It can be altered without a trace, either leading to fraudulent wills being enforced. And again, it comes to this concept. I tell everyone that this idea of wills and estates, there's no police body that polices all these things. People are left to their own devices to act in good faith and do things honestly with integrity, right? So these issues can come up with electronic wills. And it's also difficult to revoke a will. Again, this is something that's fairly new, so there's not been much litigation in court history, so there's no guarantees to how these wills are going to be probated, if issues, and which issues can arise from them. But the biggest thing we find, well, one of the biggest things is when I'm completing wills with clients, it's a constant determination of capacity, undue influence, all those things get checked. And it's not something that just happens once, it's an ongoing part of this process. And with digital wills, that makes it very difficult to do so. All right, so I'm going to start. So that's just something I want to cover before, because I know that issue has come up and there's been questions about it. So what to do when someone passes away. So first is identifying if there's a will. A lot of people think it's easy, but there's a lot of steps to this. It's often overlooked. And some of these steps, including doing a will search with vital statistics, which should be done, has to be done for the registry side, because they will ask for those search results. And searching property, including digital sources for records and any notes to a will. So because I mentioned there's now electronic wills that have come into play, it also ties into this extremely, which I think is this dangerously broad term of what a will is, which is essentially anything that can be a record as long as it's manifested in writing and speaks to or constitutes intention. So obtaining even a digital company to search computers and devices, because nowadays we're seeing that a lot of people in the newer generations are embracing technology, so it's likely to see a lot more digital wills that are surfacing. Discussing with family if there's a safety deposit box. We don't recommend storing a will in a safety deposit box generally, because the bank may ask for authority under a will to access it, so there can be difficulty getting the will if it's in there. And then contacting lawyer notary firms, because some firms will actually keep wills on hand, like the original will can be kept in a lawyer's safe to be stored. Our preference is for clients to always store their originals themselves, and we just will provide a certified true copy, and we keep one on our records as well. That's just my practice, but I think it makes more sense, because then those clients have control. If they move, they're letting people know where it is. And yes, at this time, the executor appointed will would make a list of the assets and liabilities as well. This is something, again, that's an ongoing discovery process. Nothing happens in these watertight compartments. It's just an ongoing thing that continues. So if there's a will, very simple, might have to go through obtaining your grant of probate. If there's no will, similar, it's just called a grant of administration. If the estate is less than $25,000, you might not need one. And that really helps to facilitate dealing with estates where there's not a lot of value there, because of course, people don't want to be spending thousands of dollars to try to get a grant if the estate isn't worth that much. One of the issues that come up I've seen with clients is saying, well, how do I know what the value of the estate is? So there's processes you can go through to determine that. Sometimes it's really doing like a cost benefit analysis to say, okay, with the knowledge I have right now, is this something I want to proceed with? And if the estate value is negative, meaning that there's tons of debt, maybe someone just decided to like spend all their money, rack up the credit cards, go on tons of cruises, then it is recommended that nobody step forward to obtain the grant, because you might be personally liable for settling those debts, which a lot of people aren't very too familiar with. So I always say, if there's not a lot of funds in that estate and there's lots of debt, it's better just to step back. If a creditor wants to come and try to deal with it, they can go nuts. Although some try to go through this process of obtaining this grant themselves, it is technical. You're dealing with the registry. There's a lot of liability. We strongly always suggest retaining a lawyer, even if you think it's a simple estate. We also want to really highlight notaries cannot perform any estate work. Also, sometimes clients will try to start this process themselves. They might file incorrectly, can take months, sometimes even years to correct an incorrect filing with the registry. Depending on where things go, trying to get in touch with people, starting that process properly from the very beginning just makes things a lot better, cost effective. But yeah, this kind of goes back to something I always say is when you're naming someone as an executor in a will, you're not giving them the gift of something sentimental or amazing. You're really just giving them a huge amount of liability and a huge burden. Which needs, you need to have someone be an executor. There's nothing wrong with that, but just recognizing that's the purpose behind it, so that executors or administrators are aware of that personal liability, especially when it comes to the CRA and taxes, so that they can handle estates. Once the court approves everything and the grant is issued, away you go. You now have the legal authority to deal with the estate. You have to itemize and safeguard the estate assets. So something that we do as executor, but also as clients, always recommend go in with the camera, take pictures of everything in the home, document and itemize everything. After you obtain the grant, of course, you can start to secure assets, liquidate them, put out notice to creditors, retain an accountant. I'm not saying this happens one after another, but these are all responsibilities, of course, not limited to just this, but these are some of the major ones. But it does take a long time, because that's the common question we ask is, how long does this take? Well, we won't know because there's a lot of third parties outside of our control, like the registry time frame, but you can always, estimate 1 to 2 years. States can be challenging, you have spouses or children, biological, adopted, who have an inherent right to challenge an estate, and the litigation process can tie up an estate for years. I always say this to clients because people ask, like, who can come forward and make a challenge? Well, we live in Canada. Anyone can bring a dispute. Anyone can bring anything to court. It can be frivolous. It can be baseless, but people can do that. And it needs to be, you can't ignore it. You have to address it regardless. So that's something just to be mindful of. So this is the second last big thing I wanted to really discuss is this misconception that property held as joint tenancies or as joint owners simply passes to that person. So sometimes people will name someone on an account, a bank account, as themselves. Between spouses, this assumption can most often hold true, that it's fine if there's two spouses that want to share assets and pass to one another. But between a parent and a child or another party, there's what we call presumption of a resulting trust. So to explain it kind of an easier way, just say that I have my purse and I hand it to Tammy and I say, hey, Tammy, take this. And then the stress of my presentation makes me die right away. And now Tammy has my purse. Well, does Tammy get my money in my purse, or did I only hand my purse over to Tammy to safeguard and hold? This is this idea of a resulting trust, which means the remaining party, Tammy, is holding that property in trust for my estate. They're not the true owner of the contents of my purse. And so an example here where we set out where a parent has a joint account with a child, parent dies, child assumes that they can claim the money as their own. So the child's like, okay, well, I'm on joint account. I get this money. No, the child has to continue paying for the maintenance of the account. But any funds that are actually held are there held for the estate. So they can't just take the funds and use them. But some challenges can even be brought for real property held as joint tenants between a parent and child or another party. Again, this comes back to that whole concept I mentioned of bringing disputes. So again, this is why we prepare additional documentation to demonstrate the true intention of adding joint owners to any property. It's not 100%, but it's better than nothing, and it does help. It provides something for the courts to lean in on. We generally don't recommend parents hold property jointly with children. There's a number of reasons for that. But in cases where it makes sense, then we can provide additional documentation to company will. Safety deposit box, example of that is safety deposit box just means that you have the lease agreement to the box, not what's in it. And we have heard of professionals giving clients incorrect advice in this area. And we simply, we've had issues like this come up. And we've heard people simply advising that they can have everything. These clients come to us and they say, oh, I thought I was on joint, so I got everything. So-and-so told me no. But it's much easier for us to advise and deal with this in the beginning than to have issues down the road, because a lot of people are trying to avoid probate fees. For some reason, that's the big thing, avoiding probate fees, avoiding taxes. But sometimes, you know, what's that saying? Penny wise, pound foolish. So it's a common misconception, and it's often due to part of it is with the professional drafting of wills and not having experience with people who are trying to help others draft wills. So this is the last big thing here is the notary limitations. So there's been a court decision already that came out a few years ago that limits notaries with, I think, 3 very basic types of wills they can prepare. But a will in which the beneficial interest vests immediately on death. So essentially, everything has to be very clear cut. Everything's given right away on death. You know, it's just a very simple one. But the issue that comes up is, when is an estate simple and basic? And if someone isn't understanding the law and the courts and seeing litigation, like, you don't know what you don't know, right? And this is kind of comes back to that presumption of trust thing I mentioned. And then notaries also do not handle estates and are not required to stay up to date on estate law matters. So one of the things lawyers do is we always have to see what's going on, what are changes coming down the pipe, so that we're on top of any legal changes, any court decisions that can shift laws regarding wills and estates. But if you're not, then you're unable to really fully advise on what can happen down the line. And this can lead to estate disputes between family members or additional costs and liabilities from an improperly drafted will. Therefore, it's our opinion that all estate planning should be done by a lawyer with experience in estate planning and estate administration. Some notaries actually charge more than lawyers to prepare a will, and some lawyers also charge much less for a will, as we make our business from perhaps subsequent estate work, whereas notaries aren't able to perform such work. But for our wills, it's not our bread and butter, but you're getting it done by someone who's qualified, who knows what to do, who can identify huge issues that can come up from personal liability too. I'll kind of go through this really quickly, but just dealing with complex estates, everyone thinks everything's simple, but you don't know what you don't know. So these issues come up where we're advising clients, no, this is not simple. This is what you need to deal with. There's also non-lawyers who purport to be able to draft a will at low cost or no cost for their clients. And despite having no legal training or expertise, these are issues we've seen come up. There's also situations where a more complex estate plan is warranted. So ownership of a business, blended families, assets in other jurisdictions. If someone's a dual citizen, that can come with huge income tax implications as well. At the end of the day, don't try to fit a complex situation into a simple will to try to save money. That's something we see very often, is notaries saying, well, we can deal with this. We think this can be simple. Let's fit you into this simple box to get your will done. It can potentially cost your estate thousands of dollars and lead to disputes between your family. So that's, again, why we always recommend getting it done by a professional. But yes, that's kind of little bits here and there. Of course, it would take a long time to go through everything because it's such a huge topic, but feel free to get in touch with me if you have any questions or comments. Thank you.